Actually,
Yes.
I mentioned item number 11.
Yes.
Uh, Service report in respect of respondent number 6 is still awaited. I pray that it may be urgent for today.
Trial code record is also still awaited. Item 11.
Item 11.
Okay. Who you are for?
I'm for petitioner.
Okay.
It's last.
Record receipt. Okay. You are Mr. Arku, Rani Council for the petitioner is present. Your correspondent,
Respondent number 1 to 5.
Mr. M. Kambo, Rani Council for the respondent number 1 to 5 is also present. Stop. The office note dated 7/4/2026 reflect that the service of notice upon the respondent number 6 is still awaited. In view of the above, let this matter be listed after
3 weeks.
after 3 weeks. Okay.
This is free.
The interim order passed earlier shall continue till the next date of listing. Okay.
May I, Lordship?
Yes.
I beg to mention item number 20. Last item. The conducting council is out of station. Matter may be adjourned for today and next date may be given.
This for respondent, no objection.
Objection.
Okay. Mr.
Jitala.
Jitalo, who is conducting council?
Jitalo. I'm Jitala. On behalf of Jitalo, I'm appearing.
Okay, Jitala. Land Council, some mistake. The conducting council, Mr. Jitalo is out of the station. Therefore, pray for adjournment. To which the Land Council appearing on behalf of the respondent has no objection. To which Mr. Miss Jeannie, Land additional AG, additional PP and Mr. D. Laji, Land Legal Aid Council. For the respondent has no objection. Prayer allowed. List this matter after
2 weeks.
2 weeks.
Much awesome. Item number 1.
My lord, may I interrupt, my lord? My lord,
Yes.
in item number 18, I think it has been mentioned, my lord.
Item
18, my lord.
18 not yet mentioned.
My lord, Mr. D. Penging has informed me that his junior will make a mention. So I have no objection, my lord, if it comes up after 3 weeks, my lord. Item number 18, my lord.
Item 18.
18, my lord.
So
I'm appearing for the FCI respondent, my lord.
You are for the respondent.
Yes, my lord.
Okay.
PK Singh,
You
my
have
lord.
consent for. Okay. So the petitioner has consented.
Yes, my lord.
Mr. BK Singh, Land Council for Land Standing Council for Food and Civil Supply Department.
Food Corporation of India.
Food Corporation of India.
Of India.
With the consent of Land Council for the petitioner. Praise for listing this matter. When you
After 3 weeks, my lord.
matter after 3 weeks, the prayer is allowed. List this matter after 3 weeks.
Highly
Okay.
obliged, man.
Yes.
This is a decision for a tax report who is invested on a 4 March 2025 by a great administration. Now, who is we a report more than 300 characters.
Okay. What is the offense that is against you?
Under section 326 G/104.
Murder.
Okay. You filed bail application before the trial court earlier? Rejected. When it was rejected?
Rejected on 24 September 2024.
Page?
Page number 55 there, no? And it's just
Charge already framed.
Yes.
Evidence already recorded.
yes.
Trial commencement.
Okay. So now what is the ground for your bail this time? Your bail was rejected.
Yes, sir.
And then what is the ground you have taken
They brown
for release?
for maybe hampering of tempering the physical threat.
What?
Hampering the tempering the physical for a rejected one.
No. This, the ground taken this time for release. Why should the court release you? When the other court has, when the trial court has already rejected you on the same ground?
It's wrongly indicated with the case here. IO is not properly investigate that.
Charge already framed,
Yes, sir.
found prima facie case against you.
But
That is why trial is going on. And the court says that it's not proper, since there is a prima facie case against you. There is a material against you.
My lord, whether there is any other criminal cases pending against the accused or not, that has not been mentioned, my lord.
That is a must now, made mandatory. It's- Hmm. No such application. Only says no such application, but then you have to state there is no other criminal cases pending against you in any other court. Hmm? Why you have not mentioned? That has been made mandatory. Is there any case pending against the present accused person?
No.
You have to mention then. Why you did not mention? Hmm? What is the point for calling even the record on the same ground? So, Mr. Ete, what to do?
My lord, now it's a mandate to mention declaration that whether,
Yes,
because it has to be supported by the affidavit, my lord.
Mhm.
So as to understand whether he or she is a habitual offender or not, the declaration is there, declaration has to be made.
Mhm.
Otherwise, they can file additional also, or they can file a fresh also, my lord. So that requirement has to be fulfilled, my lord. So far as the declaration for pendency of application before Supreme Court is concerned, that has been fulfilled, but not the other one, my lord, whether there is any criminal case pending against her or not, my lord.
So, what is your prayer? You want to file a fresh?
Yes, sir.
Want to withdraw?
Yes, sir.
Okay. Mr.
Yes.
Tilaji, learned counsel for the petitioner. Praise for allowing him to withdraw this bail application with liberty to file a fresh by incorporating by making necessary amendment. The prayer is allowed. This bail application stand dismissed as withdrawn, on withdrawn. Okay,
Oblige.
with liberty as prayed for.
Yeah.
Okay.
Oblige.
Item number 2.
Yes.
My lordship, this is a joint petition under section 528 of the BNSS for causing and setting aside of the charge sheet number so and so in corresponding to eternal PSK so and so under section 326, 201 and
What is
32 of
326?
IPC.
IPC.
Yes, Your Honor.
Okay, so this is before.
The case is pending before Judicial Magistrate First Class UPN at the stage of appearing.
The charge.
CC
Okay,
Yeah.
charge sheet filed.
Yes, Your Honor. And this petition has been filed on the ground of compromise right between the parties. Page number 53.
FIR was probably after 29/8/2023. Still in under IPC it appears.
Yes, my lord.
Hmm.
But otherwise also, my lord, the cognizance order, my lord,
Hmm.
now is held in, my lord, the Honorable Apex Court
Hmm.
in Paramjit Batram case, my lord.
Hmm.
That it has been held that when the party is praying for quashing of the criminal proceeding, my lord, and if the trial court has already taken cognizance,
Hmm.
then FIR, charge sheet, as well as the cognizance order must be specifically impugned and made a part of the record, your lordship.
Have they met? No.
Cognizance order they have not annexed, my lord, and it's not a part of the record, my lord, because while on that stage only, my lord, the criminal proceeding pending before the trial court. And GR number comes on immediately after filing of the FIR.
Right.
So for that, the cognizance order has to be impugned or made as a part of the record. Otherwise, your lordship, this relying on the same judgment in Biswa Buddha by the Allahabad High Court, my lord, it was held that the same will not be maintainable, failing which the same will not be maintainable.
You have not challenged this cognizance order.
Yes, Your Honor. Our proceeding has been challenged, and if this petition is admitted today, and we will file IA for that also.
P26.
Yes, my lord.
It's a grievous.
Grievous, my lord.
Whether any evidence, prosecution witnesses has been examined
Yet not.
already? No, huh? Not yet.
Yet. It's still in the appearance. Yet CC has not been done in this case.
Cognizance second, notice
Okay.
issued for appearance, and
Appearance,
after that,
correct.
my lord, CC for claiming of charge.
Okay.
Case is at the initial stage, Your Honor.
So, call for the record.
Yes, my lord, call for the record, and my lord,
And in the meantime,
my lord, the issue here is, my lord, although it sounds to be very the simple one, the procedural aspect. If
have not-
the case is challenged, if root is cut, then tree will goes up. No, in criminal procedure, it's not like that. Every branch, every leap has to be challenged, put into challenge. So now, in criminal proceeding, normally in criminal proceeding, there are two parts, my lord. The first part is the investigation part, and second part is the criminal proceeding. During the course of investigation, the trial court do not have any power to do with the investigation, except for the supervision, which they cannot directly involve. And second part, after taking cognizance, the criminal proceeding initiated, wherein the police investigation authority got nothing to do, my lord. So if they are challenging the criminal proceeding, then they have to challenge the very order itself, basing on which the criminal proceeding has been initiated, my lord.
that has not been
The
challenged.
death has not been challenged, and now they are praying for quashing of the GR, which is the corresponding to the FIR immediately after filing of the FIR.
You need to challenge, it appears. Now,
But I will
when the cognizance taken?
refer this judgment only. My lord, the 2025 SCC online ALL 7986. Herein, my lord, in paragraph 12, my lord, the Honorable High Court has given stress to the judgment rendered in, my lord, Paramjit Batra, my lord. And after that, para 12, 13, my lord. Para 13, my lord. Thus, apex court in Pradnya Pranjal Kulkarni Supra has clearly held that for
Para 13.
13, my
Yes,
lord.
yes.
Para 13.
Hmm.
Thus, apex court in Pradnya Pranjal Kulkarni Supra has clearly held that for quashing of the FIR, the High Court can exercise jurisdiction under Article 226 of Constitution of India, and if charge sheet has been submitted and cognizance has been taken and the same has been placed along with the FIR on record, then the same can be quashed by invoking Section 528 BNSS or Section 482. Now, my lord, may direct come to para 17, my lord.
Yes. Yes.
Para 17. The applicant has made following prayer in the present application to allow this application and quash the first information report dated so and so, registered at PS Civil Line, Meerut, giving rise of the registration of crime number so and so against the applicant and two other for the offense under Section 420, 467, 468, and 471 of the Penal Code 1860, prayer 2, any or to pass such other further order as this Honorable Court may deem fit and proper under the circumstances of the case. Now, my lord, finding 18. From the perusal of the prayer so made in the present application, it is clear that the applicant has simply sought for quashing the FIR and he has not placed the charge sheet as well as cognizance taken on the charge sheet by the competent court. Thus, in view of the judgment of the Honorable Apex Court in Padnya Pranjal Kulkarni Supra, since the charge sheet and the cognizance has not been placed on record, FIR cannot be quashed by invoking the provision of 528 so and so. Thus, in view of the above, present application is not maintainable. Here it has to be, even if it is, my lord, not challenge, it has to be made a part of record, my lord.
Yes.
So the
So
court
then-
can analyze.
What do we do? You want to withdraw and file a fresh?
I may
It will be
I may
better.
be allowed to file the IA for cognizance for the,
Yeah.
yes, Your Honor.
For that, my lord, how the criminal proceeding can be stayed, my lord, if cognizance order is not impugned? An investigation part that's already over.
I better you obtain the copy of those order by which the case has been taken cognizance by the magistrate, and also annex a challenge the charge sheet also. It's better instead of correcting all around.
And liberty may be given.
Mr.
A border.
Then counsel for the petitioner who wants to withdraw this criminal petition with liberty to file a press by making after making necessary correction. The prayer is allowed. This criminal petition is dismissed with liberty as prayed for.
Deeply.
Deeply obliged.
Item number 3.
Yes,
May I, Your Lordship?
yes.
Your Lordship, this matter is for quashing of an FIR dated 28 January 2026, which is registered at Dambok Police Station at Long Dibang Valley District.
Okay.
Your Lordship, the FIR is registered under Section 140 Clause 3 of BNS for kidnapping, Section 126 Clause 2 of BNS for wrongful restraint, Section 127 Clause 2 of BNS for wrongful confinement, Section 351 Clause 3 of BNS for criminal intimidation, and Section 3 Clause 5 of BNS for common intention, Your Lordship. The fact of the case is that the informant, the accused person, and the deceased person all are joint petitioners in this case.
Okay. FIR was registered thereafter.
They are,
When the FIR was registered?
it was registered on 20 January 2026, Your Lordship.
Okay,
Uh,
then,
the informant, who is the wife of the deceased person, has lodged an FIR against the accused person in a false belief that the husband was being kidnapped by the accused person along with 10 other members, 10 other persons. However, this is not true. This is not a fact, Your Lordship. The informant, upon realizing her fault, has decided to withdraw the FIR. Moreover, the husband of the informant was reunited with the family members.
what happened? Whether the case was investigated,
Uh,
charge sheet filed,
It is, Lordship, PS case, Lordship. For crossing of the
Not
FIR,
yet.
Lordship.
charge sheet not yet filed.
No, Lordship. So case study may be confirmed, Lordship.
Your Lordship, there is a settlement agreement between the three parties, Your Lordship. They have
Maybe-
come to an
Which one is
agreement.
not compoundable offense?
Kidnapping, Your Lordship.
Kidnapping, 143.
140 clause 3 is not compoundable, Your Lordship.
140 clause 3 is,
Not compoundable.
this is, what offense is this?
Kidnapping, Your Lordship.
Kidnapping. Just a minute. Group of 10%. Okay,
Your Lordship, however, the FIR has not been registered against those 10 person. It was registered against only one person.
okay, that's in my approval, sir. Where is the application for withdrawal of FIR?
Your Lordship, I have not annexed it, Your Lordship.
Why?
There is no such application.
Hmm?
Yes. Yes, Your Lordship. There is no such application for withdrawal, but there is a settlement agreement between the three parties, Your Lordship.
No, after settlement
Yes.
agreement,
Yes.
have you filed application
No, Your
requesting the IO of the case not to proceed with?
Yeah, no, it is not there, Your Lordship.
No. Then the case is pending. IO is still investigating. And
Yes,
you are
Your
filing before this court. Not inform the IO also.
Your
Hmm?
Lordship, they have falsely accused a person actually. The FIR was
Any person have
registered.
been arrested?
We have,
Person to the registration of this FIR. Any person have been arrested?
No, Your Lordship.
No arrest.
No arrest, Your Lordship. This FIR was registered out of misunderstanding, Your Lordship.
Who said?
The informant.
That is why.
Yes, Your Lordship.
Then you should withdraw the FIR from the IO itself. Says that out of misunderstanding we filed this. Kindly not to proceed.
Yes, Your Lordship.
How do we quash without knowing anything? And then the IO is after registration by utilizing the government machinery. He is investigating the case.
Yes.
You switch on there and come here to switch off that one. It's very difficult. You better make an application before IO not to proceed with. So now calling at the investigation stage, it will be a little difficult to interfere with
Yes.
the investigation of the case. In the meantime, you make an application before IO And then file that also by way of filing additional document. So the record need to be called for.
Lordship, case study need to
Case
be
study.
called for, yes, Lordship, because under
But what
investigation.
can we do in the investigation stage?
Lordship, here, Lordship, they have, Lordship, in the FIR, there are 10 people, Lordship, 10 persons.
Yes.
Whether all are been, Lordship, raised.
That is what they need to clarify before the
Yes,
eye of the case.
Yes, a case study may be called for, Lordship. And what stage the investigation is going on, Lordship, that should be revealed, Lordship.
In the meantime, you have to take steps. We are not going to interfere with the investigation of the case.
Yes, Lord.
Otherwise, unless you take necessary steps for informing and withdrawal, etc. Okay. Miss,
Ms. Kinyorak,
Learning Counsel for the petitioner. Also had Miss El Hage, Learning Additional PP for the state. This application has been filed jointly by the petitioner under section 528 BNSS 2023, paying for quashing of FIR dated 21/2026 under section registered under section 143, 126(2), 127(2), 351(3), 3 within bracket 5 BNS 2023. Setting aside of FIR number, FIR number 2, 2026. Before the dated, after that it will come dated, 21/2026. Lodged before the Dambuk police station. Register and then come register on the section, stop. Issue notice since Miss El Hage, learned additional PP. Accepted notice. No formal notice need be issued. Call for the scanned copy of the case diary. List this matter.
Lordship, 12th of February, Lordship.
12 February.
Okay. All right, Lordship.
Item number 4.
My lord, this civil revision petition, my lord, is filed for quashing of Corona, my lord. I can. This civil revision petition, my lord, has been filed.
Who appear for the respondent?
Lordship, I am for all the respondent, Lordship.
All the respondent?
Yes.
So record was called for, it appears.
Yes, my lord, the record was called for, but
The office note says that
yes, my lord, the record was called, my lord, but my lord, this is covert case, my lord.
what covered case?
My lord, on same issue, my lord, this
The calling for records return back to this registered postal no insufficient address. Record not received, not yet received.
Yes, Lordship.
It has come with it has returned with the record with the report that it is insufficient address. Where from the record was to be
Lordship,
called
but
for?
records may be called from the, my lord, the impugn for one I issued, Lord.
Mhm. The record was
my
called
lord,
for from the.
from my lord, all West Young District,
Yes, Lord.
Gaupura Association.
Hmm. It has not yet been received.
Next.
Have you seen the office note?
And not yet, Lordship.
Is record necessary or not?
I
For-
think, Lordship, the record is not necessary.
Not necessary, madam.
Not necessary.
Yes, madam.
It was called for. But it was called for.
It was all for the, my lord, in this case, my lord.
Yes,
Yes,
it was called
yes,
for on the
madam.
initial day from the Gambura Association, Alo. And return saying that the address is insufficient. You're challenging the order passed by the Gambura.
Yes, madam.
He is challenges. I'm challenging the, I filed the appeal, Lordship. In this case, Lordship, private respondent, some of the private respondent, Lordship,
Okay.
filed the appeal
Hmm.
against the judgments, cover decisions of the village authority
Hmm.
before the inter-village council,
Hmm.
which is impugned in this. On the basis of the appeal, again, this Gambura Association as a inter-village council
Hmm.
issue a corona notice for the convention of Kaba, inter-village Kaba, as an affiliate authority, which is challenged by the petitioner in this case.
On the ground that Gambura,
Why record is not necessary?
because my lord, this is against, appeal against Kaba decision, my lord. Before,
That is
No,
why
this- no
record
existing
probably is
quorum.
necessary.
there is no quorum called Gambura Association, my lord, in the AFR, my lord. So my challenge is that Gambura Association has no power and.
That is why that is why probably how they maintain the records and what basis they have issued. They want to, the court want to examine. That is why the record was called for.
Then, my lord, you can,
You figure out and ascertain the correct address of the person or the association who passed this order.
my lord,
Ascertain the correct address.
my lord, in page 52, my lord, their office address has been written, my lord.
Hmm.
Hmm.
No, have you seen the office note?
Not the Lordship.
No,
The postal says that insufficient address. Address is insufficient.
Lordship, otherwise order may be passed, directing the petitioners to furnish the order to the this chairman, Lordship. So that
Dusty.
yes, yeah, no,
By-
Lordship, order may be passed, Lordship, and order may be communicated by the petitioner, Lordship.
Lord, if this court permit, my lord, I will provide office address, my lord.
Hmm?
I'll provide office address to the registry, my lord.
Copy to the
Office address, my lord.
office address.
Yes, of this Gambura Association, my lord,
Okay.
to registry, my lord.
Your name?
El Nosi, my lord.
Lanet El Nosi, Lanet Council. El Nosi, Lanet Council for the petitioner. No, in view of the office note dated 29/7/2025, Mr.
Number.
El Nosi, Lanet Council for the petitioner,
That's the
prays for
thing.
some time to provide the correct address of the
All West Siang District Gambura,
all
West Siang District Gambura Association.
all West Siang District Gambara Association. I think you have to take fresh step, that means.
Steps, my lord, I have made party respondent number 7 and 8, my lord. By name, my lord, to the President and Secretary of this Gampura Session, my lord, whom Mr.
Okay,
Abami.
for the purpose of calling the records, no? For the purpose of calling the records from the state authority.
But in this case,
Within-
individually made me a party.
Hmm?
In this case, individually made a party, not as a,
Individually.
yes, Lord.
By name, my lord.
By name made a party,
Okay.
not a president,
President and Secretary has been made part, my lord.
but in by name.
Saying that they are not the proper authority.
Yes.
They are respondent number?
7 and 8.
Okay, 7 and 8. The prayer is allowed, huh? The petitioner shall furnish the correct address of the authority within 3 days from today. Okay,
Okay, ma'am.
then list the matter after 2 weeks, 3 weeks. Okay,
Till then, my lord, interim may be continued.
there is interim.
Yes, ma'am.
Okay, the interim order passed earlier shall continue till the next date of listing. Okay.
Okay.
Item number 5.
Lordship, Mayor Lordship.
Yes,
Lordship, here in this case, I had been there in the custody for last 146 days. And charge sheet has been filed and it's been 53 days now. And just I have not received all the charge sheet, but I've received the front page. So here actually I have, if Lordship allow me to submit.
no, have you received the trial court record?
Yes, it was called, my lord, on last occasion.
Have you received?
Not yet received.
Okay, no.
Yes,
Not yet received.
Charge seated, my lord.
Charge sheet yet.
Yes, my lord.
So,
What is the status of the trial?
Not yet began, my lord.
Not yet.
Yes, because it was only forwarded on the November, this month, my lord.
Which court?
JFC court, my lord, it is forwarded in the JFC UPA. That is in page number 29, my lord. Page number
It's a
29.
magistrate tribal case.
No, my lord.
Yes,
it will-
Lord.
Yes, yes.
yes, Lordship. That's why even,
12 December only, my lord.
yes,
12th December.
Yes,
yes,
my lord.
it's a 53 days, 55 days now.
Okay, your bail was rejected earlier
Yes, Lordship.
by
and-
the session court.
Yes, Lordship.
What is the offense alleged against you?
Yeah. Lordship, offense allegation is 308.
What is 308?
That's extortion. And whereas Lordship, that's principal up to 7 years.
Okay.
And I'm not involved in this case, Lordship. Actually, the man accused is,
But the trial court has rejected your bail.
yes, and that was the technical part where we submitted that there was non-compliance of 47 and 48. And subsequently, there was observation that it's a serious offense. So after this 77 New Delhi PS case, subsequently they had shown arrested 82 New Delhi PS case. But in that case, that same court has granted bail.
There are 2 cases.
Yes.
You
But
are also involved in 2 cases.
no, I'm not involved in 2 cases. First case is this same case, this 77.
Hmm.
After this, after 1 month, once we tried to move bail, then they had threatened us by stating that we will drag you in other case. Subsequently, they drag us in 1 more case. This,
Okay. Now there are 2 cases.
yes. But in that case, there is nothing. They had granted bail and bail order is also there in this bail petition. It's there in Lordship in page number 27, Lord.
Where is the statement you have made that you are also involved in another case? In the bail application?
Lordship, here,
And then the status of that case, where have you?
it's in paragraph 2, where means I declared that the alleged accused person is not involved in any other case except this subsequent means shown arrest case.
Hmm?
So shown arrest case. This is not exact case where means I had been shown arrested, just shown arrest. I
Where?
was
Where?
From judicial custody only.
Okay.
From judicial custody, and they just shown arrested. Just to
So shown arrested means what we could understand is you have been arrested in that case.
yes, Lordship.
So
So that case is under investigation, but that's the same case. That's a extortion case only, and that extortion note has been given. by-
extortion case only.
yes, Lordship,
Okay.
that has been given by someone else. I'm not there in this case, and even my mobile number is not used.
Just first, only the simple question.
Yes, Lordship.
Are you involved in one case or two case? Two cases.
According to me, I'm not involved, but according to them,
No,
they
no,
shown
you are-
arrested.
See,
Yes.
all the accused
Yes, Lordship.
are innocent.
Yes, Lordship.
We understand. But then now, are you involved or stated by the police that involved in one case or two cases?
According to them, they
You
had
have-
shown
you have been-
arrested.
okay,
Yes,
shown arrested is involved.
but
So where is the statement that you have made that you are also involved in that case? Where is that?
Lordship,
You have to declare that you are also involved or not involved in any other case other than this. Where is that statement?
it's there in paragraph number 2, Lordship.
Yes.
Where means that the petitioner humbly, that the humble petitioner humbly begs to submit that the alleged accused Sri is a single son of this, and son of this. Therefore, as a wife, declare that the alleged accused person is law abiding citizen and has no criminal antecedents whatsoever, and he has a good moral character over the alleged accused person, that. And subsequently, bail rejection is there in paragraph number 3, where means I clearly stated that in one case I had been granted bail, where means I had been arrested.
What is this? You said that not involved in any other case. And yet stated that subsequently granted in another case. The simple, straightforward.
Yes, I got that.
That you are also case pending against you. The another case is also pending against you under section so and so. Why you don't say that one?
Lordship, here,
That statement would be required probably.
Lordship,
Hmm.
Lordship, here, actually, here in this case,
Yeah, in this case also you are innocent, we know, but then you have been dragged into the cases.
yes,
If you are dragged into the 10 cases, in all cases, even if you are innocent also, you have to state here.
yes, Lord.
You are innocent, we know, but then you have to state that there is a case pending against
Yes,
you.
Lord.
It is under that status,
Yes, Lord.
that stage. So you have to give that statement. You have to declare that.
But my humble
this-
submission
this
is,
way-
Lordship, humble submission, there are catena of cases where means all the statement, mobile phone, everything has been seized and nothing has been recovered. Now, after charge sheet also, because the bail was pending from December till January. So that's the reason we moved very late over here. And meanwhile, remaining alleged accused has been granted bail.
By then you knew that there
Yes.
is a case pending against you. You have
Yes.
also been dragged in some other cases. You should have been stated.
Lordship, that's why.
Stated that also here.
And Lordship,
That is compulsory.
yes, Lordship. But the
I think you have to declare. You have
Lordship-
to make that statement also.
Lordship has discretion, Lordship.
No. How do the Supreme Court has
Because-
passed that order? That
yes.
has been made mandatory. What discussion we have? Hmm. You have to make a declaration. So in the present trial court record is also
And-
so it is in the initial stage where file and then make those declaration also.
Will make the additional affidavit over.
Additional affidavit
Yes, Lordship. And
in the bail.
yes,
Okay. Mr. T. Gipa, Lana Council for the petitioner, submits that although he had been dragged in another case, where? What is the name of number?
usually PS case number 82.
Usually PS case number
82,
82,
2025.
2025. However, inadvertently, he did not include the same, and therefore praise for allowing him to make a declaration in this regard by filing additional affidavit. Okay. the trial court record, Mr. Kurdu, Learned Standing Counsel, sorry, Special PP, SIT,
Exactly.
is also present. The trial court record is also still awaited. So in view of the above, let this matter be listed next week. Yes.
Next week.
Yes.
But-
Okay.
Once TCR available,
Petition will call from the JMC, Learned JMC.
JMFC.
yes.
Okay.
Scan copy of the petition.
Probably TCR has been called from JMFC only.
Last time
not
it
from
was
Last
station.
it was called from the session, my lord.
Okay.
Yes.
Okay, Mr. Kudus, after Mr. Kudus present, Sami said the trial to record is lying before the court of the judicial magistrate first class UPR.
My lord.
Okay. Call for the trial court record from the JMFC UPR. Okay.
My lord.
Highly
This
obliged.
matter after a week. Okay.
Item number 6. Sorry, it's 7.
Hmm.
May Lordship,
Yes.
in this case, I've been alleged to use as one of the medium of transaction in this case. So if Lordship, so I've been arrested on 08/01/2026, Lordship. And I'd been there in custody for means police custody for 6 days. And
6 days.
yes, police custody for 6 days,
Okay.
police custody for interrogation.
Okay.
Where means all my transaction I submitted, where my all document,
Thereafter, under judicial custody.
yes. And from then onwards means all the record,
When-
statement,
when
everything
you-
was submitted. And there's
when-
no further requirement for custody. That's the reason.
When you were arrested?
First, 8 January 2026.
8 January.
Yes. Arrest,
Now for how many days since then?
it's 28 days till today.
Okay, 28 days.
Yes, Lordship. And everything is on record. Nothing can be tampered, Lordship. It's on account transaction.
What is on record?
Account transaction, that money. So I think there is, Lordship, there is no record for further custody.
No, whether
If-
we have filed bail application before the trial court?
Yes, Lordship. And that was
Rejected.
based, yes.
Where is the rejection order?
Rejection order is in page number 26, Lordship. 26.
Okay, what is the observation? Why it was rejected then?
Rejected
Yes, no,
based, that was on technical ground. Where means below learned counsel has pleaded that the concerned IO has not complied with section 47 and 48.
Okay, you moved bail on
Because
non-disclosure, not on merit.
rejected,
When you moved bail application before, the
yes,
special judge for non-disclosure of the ground of
for-
arrest.
yes,
Okay, not on any other ground.
yes. It's
Okay, that was
available on,
rejected,
yes,
saying that ground was furnished.
yes.
Okay. Now
But here I have,
now here you have moved bail application on merit.
yes, Lordship. And apart from that, all the investigation requirement has been complied.
What?
As per the, whatever the IO
Hmm.
has sought the document from me. Since
Okay.
I went by myself, voluntarily I visited the police station
Okay.
and I tendered all the document.
Hmm.
And subsequently, my cell phone was seized and subsequently those bank account.
Thereafter also you have been arrested.
No. After arrest,
Okay.
once I went there,
Hmm.
then they arrested me. Then subsequently they had taken the custody for 6 days. During these 6 days, I had submitted all the document.
Okay.
And after that, from 14th of January, then onwards I'm there in judicial custody. And there is no further requirement for custody. Apart from that, I'm living there nearby in Chimpu only. It's nearby police station and I'm a driver, Lordship.
Then why they are keeping you inside the jail then?
That's
If
all.
not
That's all.
required?
If required, then
Ah,
May I please, madam?
yes.
Madam, I have queried the CD, madam.
Okay,
It seems, my lord, the account of this instant applicant, it was used to park the money for transaction. It seems so.
okay.
So his involvement is minimal as far as the investigation is concerned.
So now after parking, they have withdrawn,
Yes, it was transferred to a different account.
transferred
Yes, my lord.
entire amount,
Yes, my lord.
not giving any amount for
No,
him.
no, my lord. So he's been cooperating, my lord, as per my instructions, my lord, and as per
Ah.
the CD, my lord.
Hmm.
He's been cooperating, my lord. And then,
The
and
record of this transaction has been.
yes, everything,
Okay.
everything. His statement has been recorded, my lord.
Hmm.
And may I humbly state, fairly submit that, my lord, his detention is no more required, my lord.
Okay,
But then, my lord, only one condition, my lord, the strictness of the condition has to be put forward, my lord, because the investigation is still going on, my lord. So for future complications, my lord,
okay.
there is only requirement.
Mr. T. Land Council for the petitioner. Also heard Mr. Opada, Land Standing Council, ACB. Start. Huh? The petitioner was arrested on when?
8-1.
Hmm?
8-1-2026.
8/1/2026 in connection with which one? ACB PS case number 13.
13. 1.
Okay, 2025 under section 61 336 316 within bracket 5 318 319 of BNS read with section 7 and 13 1 A B A bracket under bracket A and bracket B and 2 of PC Act 1988. The Learned Standing Council. Standing Council only, it's not a special PP.
It's the special public prosecutor.
Special public, why it is a SC Standing Council? It is recorded in,
Sometimes it is recorded as C, my lord.
okay, now which one is,
But I
it
think
is special PP only?
it will be appropriate, I think. So.
Okay, Mr. Topadana is special PP. Fairly submitted on record that the account of the accused, what is the name of the accused?
Yaya Yangpo.
Yeah,
Yaya Yangpo.
yeah, Yampo.
Why?
Being, what is the account number is there?
Account number, yes, my lord.
Where do we find?
It's bank.
How many account, account
Two
number?
account.
Okay, numbers
It's
being
there in page number 90-91.
page number 19.
990.
Hmm?
90.
90.
90. Yes.
Where is the account number? Okay, mobile number. Where, which one? Vivo Sky Blue in color. This is vehicle.
90, Canara Bank.
This page number 90, account number 110233645860.
Annexure T, my lord.
Senate 30, page 90.
Yes, Lordship.
Is it the same? It's a type of copy.
No,
Is your list of the type copy?
Oh, no, it is page 81 in my page. I think the next page, my lord.
Next.
Yes, it is the next page. Bank account of to so and so being of the account number of the account of the accused so and so in Canada Bank being page 91 type, number of the account number. And which one?
And another is wife
92.
92.
It will be 90.
Why has also been arrested?
No, no, Lordship. Because all they had submitted all the relevant document, there is no need for custodial
Okay.
introduction. That's the reason.
So accused has had only one
One
account
account,
number and then wife one.
Yes, my lord.
Okay,
And he was-
wife not arrested.
No, not arrested.
Okay. Two bank account belong to accused being in Canada accused and his wife in Canada Bank being account number so and so in the name of accused. Okay, and account number, so which page? Wife's
92.
93,
92.
92. Account number. Where do we find account number?
Down below, my lord. 110-233-657700.
Just a minute. Where do we find that name? Canada Bank. Number is page 91. Where is the account number? So. Nomination register. Okay, okay. Not in a petition, it's not very clear. Anyway, 91, I've marked. Okay, and then 92. 92 is transaction only, it appears.
Yes,
Maybe
that's
93.
It will be 93. 93 in the name of another account in Canada Bank. Canada Bank. Okay. In the name of, what is the name of the
wife
account
is
holder?
Sita Son.
Sita Sonam.
Hmm?
Sita Sonam.
Sita Sonam, yes. Sita Sonam. And this is your young cook. Have been utilized. It have been used by the accused persons.
Yes, ma'am.
To park the amount by transferring the amount to their account. And the record shows that the said account, which was transferred by the accused, had subsequently been transferred back to the account of the accused persons.
No, it was parked by some of the beneficiaries, and from there it was, given to so many
Okay.
accused persons.
Okay, thereafter, the said amount was transferred to so many accused persons.
My lord.
Okay. Which shows that their account was only used to park the amount for distributing for distribution to the other accused persons. So the above shows that the involvement of the accused persons is a minimal in the instant case. And during the investigation, the accused has, during the investigation, the IO has seized all the required document and also recorded his statement, his police statement. And since the accused is cooperating with the investigation of the case, he's further custodial interrogation stroke remand is no longer required. Start. In view of the above, and in view of the submission made by the learned special PP for ACB and on perusal of the records, this court, and then, sorry, and therefore the learned ACB, sorry, learned special PP ACB has no objection if the accused is granted bail, however, with certain stringent conditions. Stop. Okay. In view of the above, in view of the submission made by the learned counsel for the petition as well as by the special PT, SCB, comma, this bail, and considering that the accused has been inside the custody for how many days you said?
28 days.
28 days, and his further custodial interrogation stroke remand is no longer required. This court is of the view that the accused can be granted bail with certain conditions. Stop there. Accordingly, this bail application is allowed. Stop there. The accused is directed to be released on bail on execution of a bail bond of rupees 1 lakh.
My lord.
1 lakh with one surety of like amount
Lordship,
to the
1 lakh is too
satisfaction of
much.
the IO of the case.
I am a driver.
He knew, he also availed.
Because
And then-
other has been granted bail in
He
50,000 and
knew, he
50.
cooperated.
Yeah,
Although he is now cooperating with the police, he cooperated with the accused also. So for cooperation, you have to pay something. Okay,
Lordship, other has been granted with condition with 50,000 only.
50,000.
Yes.
You are richer.
No, Lordship. I'm a driver, Lordship. On record, everything on record.
Driver knows everything. Right. Okay. Then make it equal 50,000. Okay. Is it okay?
My lord.
Okay. With one surety of like amount to the satisfaction of the arresting authority. It is to the arresting authority or the special
No,
By- to be executed before
special judge.
special.
UP.
UPA.
Okay. It should be satisfied to the satisfaction of the
Special judge UPA.
okay. Special special judge PCX UPA.
My lord.
Okay. On subject subject to the following conditions. Stop. Then that's the accused shall cooperate and appear before the IO of the case as and when required, as and when called for. Where is CRPC? CRPC. Where is the competitive table for the VNSS? Competitive. Okay. Hmm.
If my lord.
Table. Yes. Hmm. Yeah, the accused shall not directly or indirectly make any investment, threat, or promise to any person acquainted with the facts of the case so as to dissuade him. Fact of the case. And he shall not leave the jurisdictional police station without prior permission of the court. I think that is enough.
My lord.
Okay. With the above, this bail application stands allowed and disposed of. Okay.
Obliged.
Highly lordship.
Return the case diary. Huh?
Item number 7.
May I please, Your Lordship?
Yes.
I'm yet to receive the paperwork, Your Lordship. And I need to go to the trial court records to set the ground for the appeal, Your Lordship.
Okay. You want to file
Memorandum of
appeal.
appeal.
Okay.
For that, I need to go through the trial court records also, Your Lordship.
Whether have you
Paperwork.
received the trial court record? Okay. Had Ms. Kaninada Maling, Learned Legal Aid Counsel for the applicant. Also had Mr. Jitada, Learned Additional PP for the state. Start on para. The trial court record as called for has been received. Start. Miss Kaninada Maling, Learned Legal Aid Counsel. For the appellant wants to file appeal memo. Wants to file a memo of appeal. I mean, a formal memorandum of appeal.
Along with condonation.
Condonation we can condone, I think.
Yes, jail appeal.
Okay. And then some is that the appeal, this is a jail appeal. How many days of delay? Have you calculated? When the judgment was order passed? It was passed on?
2 months.
Just a minute. Huh? Or this judgment was passed on 31?
07/23.
No,
No, it's on
31/5/2024.
yes, 31/5/2024.
31. And then this jail appeal was filed when? 28.
It was filed through SP
Yeah,
jail.
but it was received by here with the register here in the High Court on 28.
Check the letter.
Issue number is 6/6/24.
No, when it was received.
28/8/2025.
So then how many days since then?
It's
24.
almost 1 year and 3 months. Filed on 28/8/2025.
28/8/2020.
And judgment was passed on 31/5/2024.
31/5.
Yes, 24.
So 455 days around.
Yes, 1 and 3 months, 1 year and 3 months. It can be because this is the
okay.
jail appeal only.
For the London Legal Council submits that there has been this is a jail appeal. However, there has been a delay of around 450 days in filing the appeal and appeal start. Therefore see praise for and there was no any intention to cause delay as it is a jail appeal. Therefore see praise for condonation of delay in filing the appeal. Condonation of delay of 450 days in filing the appeal. Stop the learned additional PP for the state fairly submits that since this is a jail appeal, he has no objection condoning the delay. Stop. In view of the above, this court also, and in view of the above, the delay of about 450 days is in filing the connected appeal is hereby condoned. Stop. Para. Yes. K. and Malin, Learned Legal Aid Council, for the praise for the sum is that there is no memorandum, since it is a jail appeal, there is no memorandum appeal, the formal memorandum of appeal. Therefore, she prays for allowing her to file a formal memorandum of appeal after obtaining the records, the prayer is allowed. The prayer is allowed. Appeal be filed with appeal be filed within 15 days.
Yes, sir.
From today. Start. Para. Since the records has already been received, comma, the after receipt of the memorandum of appeal being filed by the legal aid counsel on behalf of the accused, comma, the registry shall prepare paper book. Okay, after receipt of
Yes.
your memorandum of appeal, they will prepare a paper book
Public.
within another 30 days. List is made thereafter on the date to be fixed by the registry. Okay. So we'll get it listed only after preparation of the
Yes.
paperwork only.
Yes,
And in the meantime, unless you file, they will not be able to prepare paperwork. That is why within 15 days is given,
Mhm.
you have to file memorandum of appeal. You go through the record.
I'll go through the
form.
records then.
Okay.
Sip.
It may not be the long one, but on just the basic one,
Yes.
you can, basic contention. Okay.
Obliged.
Obliged.
Okay.
Item number 8.
Yes. Yes.
Lordship, the teacher has come, Lordship. Yeah,
It's a criminal
Petitioner.
petition.
Yes, Lordship.
petitioner is not present. It appears earlier also non-appears. It appears.
Yes, Lordship. They have
petitioner-
already granted.
Okay, no. It's been for 3 occasions. Now this is 4th.
Yes, Lordship.
The quashing petition only
Yes, Lordship.
dismiss.
Lordship, because Lordship, they have not appearing, Lordship. They are-
Yeah, that is
Lordship,
what 3 occasions we could see. Non-appear, non-appear, and non-appear. Non-appear on behalf of the petitioner on court. What is the other allegation otherwise?
Lordship, here, Lordship, actually, we have been instructed to get the obtain the instruction, Lordship,
Hmm.
regarding sanction order. For that, Lordship, we have already produced the order, Lordship, but till now we have not received any instruction.
Have you seen the record?
No, Lordship, not yet, Lordship.
Is there any material against the accused?
Lordship, then Lordship, it may be listed again on admission hearing,
Just
Lordship.
a
because-
minute. Because
Yes.
if he is not appearing, why should we list again and
Yes,
again? So pending before the judicial magistrate first class.
Lordship.
Which court? UPR. So what can we do? We can only dismiss.
On default,
Whereas Ms. El Hagilanet, additional PP, is present on behalf of the state respondent, staff, It is noticed that on 25/7/2025, 21/10/2025, and on 20, 28/1/2026. And on 21/6/2026, and then 28/1/2026 also the petitioner. No one represented the petitioners. It appears that the petitioners are no longer interested to pursue the matter. In view of the above, this criminal petition is dismissed for non-prosecution. Okay.
Lordship, much obliged.
Item number 9.
May it please your lordship.
Yes.
Your lordship, this is a criminal appeal from jail.
Okay.
So initially, my lord, this court has called for the TCR. However, my lord, the legal aid council was not appointed.
Okay.
And moreover, my lord, the only the material before us and before this court is apart from this TCR is my lord, only the judgment copy, my lord.
Okay.
So therefore, my lord, now I would like to pray your lordship may kindly direct the registry to appoint a legal aid council. And later on, my lord, it is upon the legal aid council to prepare the proper memorandum of appeal, as well as, my lord, the appropriate application for condonation of delay of 87 days, my lord.
Okay. Mr. Piete, learned additional PP for the state. He pointed out that this is it. Okay. Or we can appoint.
Yes, my
legal
lord.
aid counsel.
This
stipulated
court
by
can
the
also
court.
appoint, my lord.
Okay. No one appears on behalf of the respondent. Huh? Sorry, the appellant. Huh?
My lord, it's from jail only, legal aid
Okay.
council. No, legal aid council has not yet appointed, my lord.
Okay. Okay, Mr. Legal counsel, additional PP is present and submitted this since this is the jail appeal. No legal aid counsel has yet been appointed to represent the appellant. Represent the accused. Huh?
Yes, my lord.
Staff. Huh? In view of the above. Who else is present today? Legal aid counsel, the High Court. This is this is POCSO Act.
Yes, my lord. That is why, my lord, first, my lord, this court may appoint a legal aid council.
Hmm.
Then, my lord, the
Yes,
legal aid
right,
council has
right.
to prepare the memorandum of appeal as well as appropriate application,
Right.
and then notice will go.
So, who else is present today? Legal aid counsel. Jayadevji is present.
No one is, no
No
legal
one.
aid counsel from panelist.
Hinti Uttamburu. Rimi. Rimi is present? No.
Keeper is not present, my lord.
So, Dugi Johnny. Who general out of this?
My lord may appoint anyone from the list, my lord. It will, the registry will communicate to the concerned, my lord, the legal aid council, my lord.
Will appoint Morik Bagra. Huh? Mr. Morik Bagra, learned legal aid counsel from the panel of legal aid counsel for the High Court. He is appointed as the legal aid counsel for to represent the accused. Staff. Huh? There is also it appears there is also a delay of how many days?
My lord, 87 days
87 days.
and no memorandum of appeal is still filed. my lord.
And no memorandum of appeal has been filed. Staff in view of the above, the appointed legal aid counsel shall file memo of appeal, condonation petition as well as a memorandum of appeal.
And further, my lord, the registry may be directed to provide the copy of PCR to the legal aid council.
Since the trial court record has received, the registry shall provide a copy of the trial court record to the learned legal aid counsel for taking for preparing condonation petition as well as memorandum of appeal on behalf of the accused.
Yes, ma'am.
Okay. Stop. So then, list this matter.
After 4 weeks, my lord.
No, delay is 876 days.
My lord, there, my lord, perhaps it has been wrongly mentioned. It's 87 days, my lord.
87 days.
Yes,
delay.
my lord.
Okay. List this matter after, we'll list it, get it listed after three weeks.
My lord,
2 weeks.
let it, my lord, after 4 weeks, because he has to prepare the memorandum of
Okay,
appeal and
after
other.
4 weeks. Huh?
Yes,
Okay.
deeply obliged, my lord.
Item number 10.
Item 10.
Here also, my lord, perhaps this same order,
Same.
same order need to be passed. Yes, my lord. It's also the same case, legal aid council TCR received, but not appointed. Same order, my lord.
Okay.
But different legal aid council may be engaged.
Then here. This is regarding. So what is the offense here? Is 7 years for 304 part 2.
Yes,
Okay.
yes, my lord, 304.
Then here Jayadaji. Jayadaji is appointed as legal aid counsel. Similar order. And then a delay would be, there is a delay of 91 days. Okay. Same. Okay.
My lord, in legal aid, another legal aid council, not more important.
No, the Jayadaji.
Okay, my lord, not deeply obliged.
Lordship, at next 2 o'clock. Okay. We'll resume at 2 o'clock. So,
May I please, your lordship?
yes,
So item number 16, my lord. So I am feeling quite uneasy due to high pressure. So
16.
matter maybe refer, it's a mediation, referral, mediation.
okay.
So
You want this matter to be referred?
refer, yes, my lord.
Okay.
So
15 and 16?
yes. No,
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 only
16.
that is 16.
Only 16?
Only 16. I am Oriental Insurance Company appellant.
Okay.
So my learned sister is the respondent.
I have no objection.
No objection.
Yes.
Okay. Third, Mr. Udeka, Learning Counsel for the appellant. Also, Miss
And Sonia.
N.
Sonia.
And Sonia, Learning Counsel appearing on behalf of the respondent. You are for the claimant,
Yes.
respondent claimant. Stop, huh? This matter has been listed for referral to the special mediation drive, mediation for nation. Stop, huh? On perusal of the records, this court finds that there is an element of settlement of the matter before the media, through a mediation. As expressed by both the Learning Counsel for the parties has also expressed that they are willing to settle the matter through mediation. Stop. In view of the above, let this matter be referred to the mediation center.
Yes.
Okay. The registry shall place it. Registry shall send the record of the case to the mediation center by appointing a mediator. Okay. List this matter after the report, mediation report. Okay.
Obliged.
Matter number 12.
My lordship,
Yeah.
lordship, service is completed and as per record 4/2/2026, record are not received.
Okay. Mr.
B. Sibo,
Learning Counsel for the petitioner is present and submits that the matter is ready so far as the service is concerned. However, the trial court record is still awaited in view of the above. Let this matter be listed after 3 weeks. 3 weeks. Okay. The registry shall issue reminder for record, trial court record. Okay. Matter number 13.
Malad, in my absence, this matter came up before this honorable court. And then a pertinent issue has been raised that inter-territorial apex customary court, right, has passed another order. Now-
Subsequent to the order passed by this court.
Yes. So, my lord, the question of law in this particular civil revision is to an extent whether a apex customary court has been constituted by the state government or not. One,
Apex.
apex customary code as defined under section 2F of the AP Civil Code Act Now, this, even though the act has been enacted, creation of the Apex Customary Code, that is Inter-Village Customary Code. But then no notification has been issued by the state government with regards to the composition, that is structure. That is particularly, my lord, in administrative law, we call it as an ornogram. Ornogram would be, the example is in a district court, the Honorable District and Session Judge is the head of the district. Under him would be the Chief Judicial Magistrate. And then under the Chief Judicial Magistrate would be the JMFC. Now here, this part has not been constituted, one. So therefore, the question comes, from where this village authority has drawn power to conduct the village authority? Inter-village Apex Code, Customary Code, one. Number two, how these particular case can be settled by means of a settlement agreement. You are supposed to adjudicate the matter. Well, just before I take my lord to all this aspect. The second question that I have formulated is, what is in all statutory law, my lord will find procedure as prescribed by the law. Right from the Constitution of India, it flows to the all statutory acts and also the state legislation, where my lord will find such as prescribed by the law, the sentence. So since the structure of the customary village authority has also not been prescribed, and the procedure how to deal with has not been prescribed, from where they have drawn the power. Now, the question that flows is that, my lord, till you have to decide a title, my lord, in a normal title suit, my lord, be it in the court of JMFC or the junior division or the senior division, my lord. In that case, title suit is fine. Now there is a proper trial. You have to adjudicate it. And this has not been done. And then, my lord, and this customary court, without having the power, all the actions, my lord, which they have been done in the name of, my lord, the Apex Customary Court of District Kurung Kume is void ab initio. That is, my lord, in the legal parlance, we call it as a quorum non judice. Quorum non judice in the sense, you do not, there is no source of power given to you to adjudicate this matter in this particular way. So therefore, my lord, this particular, where is that? This is the one? Okay. Now, my lord, given the here. My lord will have this copy now.
Is there?
The one copy.
I have submitted yesterday.
Okay. What was that?
This order, you know,
Order? What order? Order of Inter-Village Committee?
22/7, yes. 22/7, 2025 order, my lord.
22/7, yes.
But this is the 26, that you see?
yes, it was
26.
it's correct.
Now, by this, now, my lord, prior to this, what happens is, there is another letter. You have this letter? Yeah. You please give it to them. I don't have a clear copy. Clear copy also. It's not yet. But it's quite. Yes.
So no, this is passed by GB Association. GB's Association.
Well, kindly see the heading, you know. The Court of Inter-Village Committee, Damin Circle, one. And next sentence is GB's Association, Damin Arunachal.
Is a recognized.
Now, kindly see third, recognized under Section 3E of APCC Act. How? This is fallacies. If this village authorities, if they do this, this cannot be permitted in this manner, Miller. So in any case, Miller, since Miller is aware, now
under section 5 of the 1945 AA formula, the GV's association is not a recognized forum.
No, association.
And this is, my lord, what the case that I've argued, that is Ikar River. And there are so many, I think your chamber also have argued, right? So this is a settled position of law. And my lord, my younger says, in today's item number 3 and 4, item 4, sure? Consent law. Oh, yeah. Item number 4 today, my lord. The same issue came up.
Okay.
The same issue came up. And they challenged and got stay order. So, my lord, in any case, since these are not part of the records in my pleading also, I cannot travel beyond this pleading, my lord. So therefore, like, just to show it, my lord, since the Court of Interblaze Committee, Diamond Circle, is not a forum recognized. See, because under the statute, although the constitution has been provided to constitute the Interblaze Blaze Authority, my lord, but no notification has come out. Till such time, they cannot assume jurisdiction by themselves. So therefore, my lord, I'll just pray, my lord, kindly interfere with this impugn order, and then we will be allowed to agitate before the appropriate forum, and then his purpose will also be served.
Yes, sir.
Yes, Your Lordship. Kindly bear this order, Your Lordship. This is the order which was passed on 26 July 2025, Your Lordship.
Yes.
6 July 2025, Your Lordship. And the petition filed by my senior, Your Lordship, it was filed on 21st September, after the passing of this order.
Yes, yes.
Yes, Your Lordship. And kindly peruse the prayer made in their petition, Your Lordship.
When we were served.
Okay, this was not challenged.
Yes, Your Lordship. My prayer is that since Your Lordship, their prayer itself is, Your Lordship, with this order, Your Lordship.
Okay. Now,
The filing of this petition is also.
Like, I'll clarify this. I'll clarify.
So this matter became, and such as on Your Lordship, my senior, he has to challenge this order.
this you have not challenged.
No, my lord, kindly see.
If you are seeking
no, no.
stay,
No, my lord, kindly see.
interfere, then you
My lord
probably
is
need to
having this
challenge this.
copy.
This is another.
Yes. You're referring to this order.
No.
No, my lord, first I'll place this and then I'll come to this order, my lord. First, my lord, kindly see. To the President, Interblaze Territorial Customary Court of Diamond Circle. This is, my lord, a communication. This is a communication. Now, this communication, my lord, has been upheld in this order, my lord. I'm sorry. Now, my lord, kindly come to the third page, internal page 3, judgment portion, my lord.
Which one? This,
The
other one, 22,
another
22/7.
7 order.
Sorry, 26 July,
36 July, yes.
third page.
Third page.
Judgment.
Page last, yes. A careful considerations of the document submitted by the appellant and after hearing the witness and Sri Waruk Dobin at length, it is found, my lord will mark this, I was not given a notice according to their finding. If they at all has to be passed this illegal order, Waruk Dobin at length, it is found that the judgment of the 3-member bench dated 6 May 2026 is ambiguous, arbitrary and biased. A clear admission by the sailor Sri Waruk Dobin that he is not the owner constitutes a strong evidence that there is no marketable title to pass. If the sailor openly admits that he has no title before or after, or at the time of entering into the contract, the contract may be void ab initio, that is, it never had legal effect. The buyer typically can avoid the contract and recover money paid. Consequently, my lord, kindly see, this paragraph is offending. Consequently, the judgment of the 3-member bench, Sri Ria Tagung, Sri Nangram Tato, Sri Sankung Tanyang, that is 6 May 2025, is set aside. Kindly see, my lord, from where can this court also can draw except for registering a suo motu case, issuing notice, hearing the parties, then only can pass.
So you are agreed by this, this order?
In their petition,
No,
they have no.
Yes,
no,
sir.
no,
Just
They
a minute.
agreed by
No,
this.
no. My lord,
Mm,
that's,
mm.
I'm telling. See, on perusal of the first paragraph of the judgment itself,
Hmm.
we were not put on notice one. We were not aware of this.
Hmm.
And we did not, this was not part before us, nor while giving brief to us, our client has passed this. Now, my lord, in any case, there is an illegality in this.
Hmm.
For the reason that these also need to be challenged, but at the same time, my lord, this order will have no foundation once my lord interfere in this. Which one we have challenged in this instant civil revision petition. So therefore, my lord, even my brother is also a court officer, I am also a court officer. It is our duty to apprise and assist the court in a right royal way, my lord, whereby there is no miscarriage of justice. When the structure of the inter-village territorial council itself is not notified, the manner prescribed how trial will be conducted. Therefore, they cannot have this jurisdiction. Even, my lord, it will have no force of law in the court. So therefore, my lord, this impugn order may be set aside, and still, if my brother's client want to use this document, you are at liberty to use.
Which impugn order you say?
Our impugn order in the civil revision petition, page 55.
If I may, Lord, see.
Yes, report.
Just a minute, let me see the.
Now,
page
my lord,
55.
kindly see, page, before I indulge my lord to page 55, kindly flip back to page 54, that is a type copy of the notice.
Yes.
Coloring near old office house, POPS coloring district, Kurungkume, mail order, my lord, kindly see. It is president and the secretary. No, my lord. This cannot be, my lord. I am so sorry with the law, my lord. The apex customary code of district, Kurungkume AP. There is no president and secretary in terms of customary code. I have done a very good research on this while writing my book as well, my lord.
What is this? KKK?
Kurungkume,
Kurungkume D4?
D, oh, which one?
District, district.
District Kurungkume, yeah.
All Kurungkume district,
My lord, see
GB,
kindly how,
GB and Gambara Welfare Association. This is association.
correct.
Yes.
Therefore, my lord, you do not have the power to do this. And then, my lord, down below you are writing. This is the notice which they have given
no,
the
so-
capacity of a association, my lord.
So.
Now the
in
order
this-
is passed
Hmm.
in the form of settlement. How this is permissible?
Which one?
The next 55, Annexure 6, my lord.
Okay, this is settlement only.
That's why, my lord.
This is,
Even say you are saying that you are Gangura. Then you, but on the top, you write that the apex customary court of district Kurungkume. If you are writing apex customary court of Kurungkume district, you have to follow the procedure prescribed by the law.
okay, this is settled, say settled.
You cannot. So therefore, my lord, kindly see in paragraph ground number 3 of kindly come to internal page 10 of my civil revision petition, my lord. (44)(1), my lord, that is still
Page
that
10,
page 10, my lord.
what is that?
Ground number 3, my lord.
Ground number 3.
Yes, the impugn mail order dated 075/2025 passed in the form of a settlement agreement is in contravention of the provisions of section 44, clause 1 of the Assam Frontier Administration of Justice Regulation 1945, which expressly provides that all suits tried by village authorities shall be decided in an open darbar in the presence of at least 3 independent witnesses. However, in the present case, no such independent witness were present during the proceedings, thereby rendering the entire settlement process legally flawed and contrary to the mandatory statutory requirement. That's one reason why I'm saying that since you do not have the power to do this, you cannot pass this order as well. Then we'll kindly see 4 as well. Just I'll I think like, yes. 4 also below. The impugned order so and so passed in the form of a settlement agreement is ex facie illegal and unsustainable law as the Mel stroke Kaba function as a lower court under Arunachal Pradesh Civil Code Act 2021. However, instead of conducting the proceedings in accordance with the procedure mandated under the Assam Frontier Administration of Justice Regulation 1945, the male members fail to adhere to the customary and statutory legal framework applicable to such dismissal. Whatever, my lord, I have argued is all flows from the grounds that I have taken, my lord. Fifth also, my lord, will see.
Just this agreement, whether this agreement is enforceable.
Not enforceable. That's why, my lord, I
Okay,
said
so, okay,
this.
you have, this is your impugned order.
Yes.
And then this is, the order dated 26th July.
This is pursuant to the communication made to the president, my lord.
Okay, now, when this order, the agreement, settlement agreement was executed,
Settlement,
4/6. No. Hmm? 7/5.
7/5.
Okay, after that this order was passed.
After that, my lord, this representation was given by them to the president, addressed to the president in the form of.
This was by the Gamburas.
Yes.
And thereafter this representation.
Thereafter, this another.
And this representation also is, you have not annexed this representation also.
Not aware of, because my
Okay.
lord, I have read.
Then you,
Why?
then probably, so subsequently this has been made available to you after that only.
No, only yesterday we.
Yesterday. So then incorporate it, this challenge it. File additional, so we'll take up. Additional
No,
affidavit.
because this has to be a separate petition, my lord. I
If
can,
it is connected with this.
even if, this has to be pending, and then we have to challenge this
Okay, separate.
separately,
Do that.
because,
Otherwise, this will, then of course, same way.
my lord, this morning also, my lord, I was not supposed to refer, my lord. This morning, my lord, in a bail matter,
Hmm.
which my lord was dealing with,
Hmm.
there is a judgment by the apex court
Hmm.
saying that if there is, and then subsequently followed by the notification of our high court,
Hmm.
which says whether the applicant is connected to in any other criminal cases or not.
Hmm.
If that is, no, that has to be made in the form of categorical averment in the bail application.
Hmm.
If it is not made, then that is suppression of the material facts. my lord.
Right. Hmm.
So then what happens on procedural aspect, that bail application needs to be dismissed.
Hmm.
So then Lordship has given an opportunity. I'm
Right.
sorry, my lord.
Yes, I know.
Please don't
No.
feel bad, my lord.
Yes.
So then my lord has.
No, there was liberty was given.
my
Only
lord
the liberty was
my
given.
lord has
Dismissed
given
on,
my
with
lord has
liberty.
given the liberty to file additional affidavit.
Hmm.
So my lord, if I.
No,
go
not
by
given. Ultimately,
Ultimate.
ultimately,
In that,
liberty was
even my
given.
lord, that the first thing
Hmm.
would be that,
Hmm.
that yes, I admit that there was a separation of material at the time of filing the bail application. So that procedural aspect cannot be cured by filing an additional affidavit. My lord,
Right.
that is what I respect.
So,
I want to share my knowledge with.
fine,
So therefore, my lord, in
then, in this case, probably the record is also still awaited. Record probably was called for.
Yeah.
Hmm.
please.
Few submission, your lordship.
Yes.
Your lordship, this settlement agreement was the impugn, which my brother was made, the Nasikia has made. It was only made a request of the appeal of the petitioner hearing. They had appeal before this customary court, your lordship. And if they your appeal, your lordship, this subsequent order was passed. Your lordship. This impugn order.
But in the meantime, they have challenged this.
Yes, your lordship.
Hmm.
And this order has already been, your lordship, set aside, your lordship. This impugn order, the paying of the chief by the customary court before the filing of this petition itself, your lordship. So this is known as, your lordship. I humbly submit that this.
Now, what now he is submitting is that this association doesn't have any power at all.
So they have to challenge before this honorable court. Filing
So
subsequent petition.
this they have challenged
Your
first,
lordship, in their.
and then they say that they will be challenging this as well.
They have only prayed for the setting aside of this, the settlement agreement.
Hmm.
So it has been already been set aside, your lordship. prior to filing of this itself petition, Your Honor. And if this court didn't fit, Your Lordship, then they set aside this order, Your Lordship. Since
Your
the-
prayer is to set aside.
Yes, Your Lordship.
Yes.
So this order may be set aside, Your Lordship. Why it is already set aside? by the customary-
I fairly agree with my
This
learned
may be
brother.
set aside, Your Lordship.
This particular order may be set aside, and then again, I have to come. He will also have some legal business and some fees. I'll also have the same fees.
Sorry, senior. But I'm not on that far. Since this in regards to compensation matter, and I'm trying to order
This is
this
set by
court of
other,
law.
other nine.
And then,
Why
yeah,
litigating again and again, Your Lordship,
How-
I'm
Another is,
prejudicing.
yes, ye
I'm
member look other
depriving
in.
of my
Oh,
colleagues.
member.
So I humbly pray that
No,
this
no, no.
matter may
there is one more.
allowed you.
There is one more thing. These, the three judges
Hmm.
who have set aside the previous judgment is by another bench, not by their own.
So what? Your Lordship, they have
Another
to
bench.
file praise petition, Your Lordship, challenging this
No, no,
order, Your
no, no, my lord.
No, this
They will immediately this
this
petition.
present
My lord,
impugn order is passed by the GBs only, I think.
yes, sir. My lord,
Hmm.
I'm just assisting my younger colleague who has respectfully submitted that kindly set aside this impugn order. That will suffice for both of us.
Yes, Your
And
Lordship,
that's
it
fine.
is right. But you
Other
know, take,
side,
kindly
only-
taking a note on
only-
this order,
yes,
Your Lordship.
Only
In your-
taking
I have
note of
submitted
this
this
order, Lord. Please,
I have submitted this order before this honorable court,
Which one?
this 26 July 2020.
We don't have to refer this then.
Your Lordship, because this order was.
Your submission will record this we,
Before filing of this petition itself, Your Lordship.
no, this,
They had to bring this.
My lord,
what he's submitting is that today he has received this order and then this, intervillage committee, he is also going to challenge this.
even if.
He doesn't have power under the act.
I don't know, but this is the, Your Lordship, multiplicity of same order, Your Lordship. Adjudicating in the same method.
Fine, fine.
It has already been
My lord,
adjudicated. Your Lordship.
no, I have no objection, even if my lord takes this on record along with this.
No, then,
Passing this impugn order.
It has already been passed, Your Lordship.
No, no.
that submission will be recorded.
Yes.
That on the basis of this, since this order has already been set aside and quashed by the another bench.
Yes.
So according to him, it has become infructuous,
And that's
according to.
challenge period, Your Lordship.
Hmm?
Same as
No, no, my lord, that finding would be adverse because my brother has considered that this impugn order
Hmm.
should be quashed and set aside by referring to an extent that the earlier impugn order has already been, the order impugned in the civil division petition has been passed by another bench
Before filing of this
before
petition.
filing of the writ petition.
And same has not been challenged before any court.
Yes.
That is my
if-
submission.
If that is the,
That will
if
suffice.
that is the case, that will suffice.
Yes, sir.
Because once this order is set aside, I can understand what consequences. I'll take care of this. There's no worry. Kindly set aside this impugned order. Because, my lord, to be prima facie, my lord, if I see, my lord, again have this page 3, the judgment post,
Which one?
that 26, no? So 26 order, my lord.
उसको करो ना इसको
Mhm.
इसको communication part है.
And then, my lord, this order is nothing but upholding the communication which they have made on 7/3/2023, my lord. And this, and then, my lord, this judgment, my lord, kindly see, prima facie, my lord will decide.
7.3 or 7.5?
7-3
7/3, my lord.
Which one?
fair.
The
Oh, 7.3 is okay. Letter.
7/3 is, my lord will see address to the president.
Hmm.
Address to the president. Can you see submission of to the president, the inter-village territorial customary code of Damin Circle, all Damin circles, GV's welfare association. One, and then see basically, my lord, the paragraph ground number 3, 4, and 5, including 6, which I have read a while ago, is on the issue of a quorum non-judice. There is no source of power explicitly vested on you in view of the notification not issued by the state government constituting the village territorial council, right? So then you do not have the power and all the order passed by you are void ab initio. So then this communication order, my lord, has been upheld in this order 26 July 2025, my lord. 2025. And then in the paragraph 3, my lord, kindly see.
3 of 26,
Page
20,
number 3.
or 26/7.
26/7 order. Judgment only. Thank you. No, 22. Let us read together, my lord, if my lord has. After careful considerations of the documents submitted by the appellant and after hearing the witnesses and Sri Varudona at length, it is found that the judgment of the three-member bench dated 6 May 2025 is ambiguous, arbitrary, and biased. My lord, let us pause together and give our interpretation, legal interpretation. Now, my lord, what happens is, if a coordinate bench of the same strength passes any order, and another coordinate bench of the same quorum differs the view and finding of the previous coordinate bench, then it should refer to a larger bench. Because they do not have the power to alter the decision of the same strength. That is what the judicial propriety will. That is one. Number 2, my lord, I find that no notice has been served to us because it has been passed on the basis of the representation submitted by your client, right? No, yes.
Actually, at the appeal of the petitioner, the open order has been passed.
No.
Appeal made by the petitioner.
So that is one, my lord. So now, see, that's why, therefore, my lord, my learned friend is also right, saying that this impugn order lacks the power, it should be set aside, and then we will take appropriate remedy against this order. Yes, that's all. Look, kindly set aside this order.
Heard, Mr. T.D. Tara, Learning Counsel for the petitioner. Also heard Mr. I. Bam, Learning Counsel, appearing on behalf of the sole respondent. Staff, Tara. This civil revision has been filed challenging, filed by the petitioner challenging the order dated 7/5 2025 passed by the customary court within bracket mail consisting of three head gamburas, all HGB, all HGB head gamburas, whereby the customary court facilitated a compromise settlement agreement between the petitioner and the private respondent with regards to the lane under the lane under dispute. The lane dispute between the parties. Stop. Para. By the said settlement agreement, the disputed land was divided equally between the disputed parties, 50 within bracket 50:50, huh? And obtain the signature of both the contesting parties. Stop, huh? Para. The grievance of the petitioner is that the impugned male stock okay. And the impugned customary code, huh? The impugned order was settled by the customary court
in the form of settlement agreement.
proceeded to facilitate a compromise settlement, yeah? In the form of settlement, huh? Instead of adjudicating the dispute in accordance with the provision of the Arunachal Pradesh Civil Code Act 2021. Stop. According to the Land Council for the, and it is submitted. The Land Council for the petitioner submits that such provision is not provided in the Act, and it is beyond the jurisdiction and not in conformity with the procedure prescribed under the Arunachal Pradesh Civil Code Act, or Assam Frontier Regulation, Assam Frontier Administration of Justice within Regulation Act 1945. Stop. And therefore, the same, and therefore pray for setting aside of the said settlement agreement dated 7/5/2025. Stop. Para. At this stage, Mr. IBAM, Land Council for the respondent, and the Land Council, appearing on behalf of the sole respondent, submits that the being submitted that being aggrieved by the settlement agreement dated 7/5/2025, the respondent approach the President Intervillage Territorial Customary Court of Damin Circle, all Damin Panyasang Circle GV's Welfare Association. What was your prayer in this representation? And prayed for?
I have made an appeal already to.
This is appeal. Where it is mentioned?
Page number 2 of the orders, 26 July 2025. Kindly, page number 2.
Hmm?
Page number 2.
By the judgment of the pre-locum statu, the respondent may release a letter dated 28/6 to the submitted appeal with. Okay, okay. Then, file appeal then before the president, huh? So and so. Against the said judgment and order, said settlement agreement dated 7/5/2025. And by an order dated 26/7/2025, the said settlement agreement dated 7/5/2025 has been set aside by the Court of Inter-Village Committee, Damin Circle, GB's Association, Damin, Arunachal Pradesh. And therefore, the settlement agreement dated 7/5/2025 decided by the customary court of Sangkung, Nangram, Sangkung, Nyolo. So these are also from different village. I think the head GBs who has decided this settlement agreement, they are also from different village, it appears. Hmm?
Double appeal.
Huh?
Double appeal case. It was an appellate forum. Again, appellate forum order was appealed by, and then this order. This is second appeal.
Appellate,
It appeared to be second appeal.
appeal against appeal, my lord, the fair English is.
But they didn't say that they are the appellate court. Or have you also or did file appeal? And is it the disposal of the appeal? This
We
agreement?
have not filed on it. It's
Okay.
my representation that each communication, president to that.
And since the and since the
President.
order dated 7/5/2025 impugned in the present CRP has already been set aside by the inter-village by the appellate court of inter-village committee, Damin Circle, GB's Association, Damin, Arunachal Pradesh, on 26/7/2025 by its order dated 26/7/2025 prior to filing of this civil revision petition, this civil revision petition has become infructuous.
My lord, kindly see
Huh.
the pertinent thing in this, once thing, I assist. And you have last page of the letter addressed to the president 7/3/2025. Yes. My lord, in March, these are the Gamuras who have written to the president. And my lord, in all this serial number 2, lockup tare. Then kindly see, my lord, this lockup tare is one of the judge.
Oh, in which case? In the other 7/5?
26, 7/5 to my lord, kindly see.
Okay, just a minute. Lokam Tare is, yes. Lokam, he himself is the appellant.
No, one can be judge of his own cause, my lord. There's the law.
So many complications, I think. Is it appeal against appeal?
Yes, my lord. And this is not permissible in law. In any case, my lord, we are not going into
So,
that.
but,
marriage.
okay.
Let them just only this impugn order, which we have
Yeah.
impugned in the CR.
And
set
since
aside.
order, since the settlement agreement dated 7/5/2025 has, according, it has already been set aside by the subsequent, in the, by the appellate customary forum, he has no objection if the present civil revision petition is allowed by setting aside the settlement agreement dated 7/5/2025. Is this your? Huh? This is what you said.
No, but objection was it?
That is what you are saying. No objection.
Yeah.
Okay.
Been set aside. The customary code.
You're right. Well, it's correct.
Hmm?
Although it is set aside,
Hmm.
but then still we have to.
It has to be seen whether this code can quash already quash the site method of city. It is already quashed.
But that's no.
So I'm keeping my observation.
Yes, Your
But
Lordship.
that's why, my lord, I
Hmm.
said, because everything has been passed without jurisdiction and being authorized by the law.
Hmm.
So on that principle only, this should be set aside. Nothing less, nothing more.
Okay. To the reference also, we have to rise it actually
Yes,
315.
I think for Mr. Rava,
No, 5 of them.
5 of them, yes.
Hmm.
including Rava.
And that's,
I was also requested to join.
so then the rest of the order,
Huh.
conclusion part,
And then
I'll do
as consented by the party,
as concentrate.
set aside.
Just a minute, one last. Okay, write it in view of the above and is agreed upon by both the Land Council for the parties. This civil revision petition is allowed. Consequently, this will be the conclusion only, but then I will have to make some observations.
Yes, my lord, before that.
The impugned settlement agreement dated 7/5/2025 passed by the customary court is hereby set aside. Okay.
Habla eso.
Hmm. Okay.
Item number 14.
14.
Your Lordship,
Yes, you have not taken step.
step not yet taken in respect of respondent number 2.
Okay. Mr.
Sita Jo,
Sidajo,
appearing on behalf of Deepangi.
Sidajo, Land Council for the petitioner.
Yes.
Right, so Father, how much time? Father, 1 week time to take
2 weeks,
steps upon the respondent number?
2 Lords.
Take steps for notice upon the respondent number 2.
Yes,
The prayer is allowed. Steps within
2 weeks.
step within 2 weeks. Step take within 1 week, but it will list after, it will be listed after 3 weeks.
Okay.
Okay, steps upon steps for notice upon the respondent number 2 be taken within 2 weeks by speed post as well as by usual process within a week from today. Staff list is matter after 3 weeks.
All right.
Item number 15.
May it please, Lord.
You are for?
I'm for the appellant.
Okay.
On
Who are
behalf
for?
of
Other side, not present.
uh,
Mr. G.
Jikato, I'm on behalf
G.
of the
Catalana Council for appellant present.
Yes.
However, no one appears on behalf of the respondent. in absence of the respondent. Okay. The matter stand adjourned. List this matter again next week. Next week after a week. Okay.
Matter number 17.
Your Lordship.
Hmm.
And item number 14, there is interim.
Okay. In 14,
Yes,
the interim
14.
order passed earlier shall continue till the next date of listing. Okay. Yes. Next.
Matter number 17.
17. Who is for 17?
No one.
Student. No one appears on behalf of on call. Matter stand adjourned. List this matter after a week. Okay.
Matter number 19.
Your Lordship, Mr. Deepangi is left for home due to some medical emergency. So kindly this matter may be fixed on 11 February. Your Lordship.
11 February.
Yes.
Okay. On the prayer of Planet Council appearing on behalf of both the parties, let this matter be listed on 11 February.
Yes, Lord.
Okay.
Finished, Lordship.
Then,
Bless.